Hey, Lark and Rose here, and there is no limit to the number of ways in which government harasses and extorts people, down from the trivial, stupid little bureaucratic idiocies that millions of people have to deal with on a daily basis, all the way up to like terrorism and warmongering and murder. In the grand scheme of things, this one's going to be fairly trivial, but it's still an illustration of kind of what you can expect from government. And in this case, it's something that Amanda and I experienced directly, so I thought it would be fun to do a little reading of this. This is something we filed in response to a traffic camera citation that Amanda got a while back. And we went back and forth. She actually, months ago, went to trial. I was going to go in and record it and keep papers organized and stuff, but no, there's the Black Plague and only one person is allowed in there. So, like, so much for a public trial. Like, heck with that constitutional right. We're pretending we're all scared of this stupid virus. But she went in and she did a great job. It took us a while to get the recording of the trial, and then filed a memorandum challenging the thing. And I'm just going to read it. It's kind of self-explanatory. I don't even need to give you any background because the memorandum actually gives the background. It's a short thing. Again, in the grand scheme of things, not really that important, but you might find it amusing and entertaining, or maybe infuriating as an example of how government actually functions, which is not what they pretend, where it's due process and you have your day in court and the rule of law and blah, blah, blah. They just make stuff up. So, here we go. Jumping right into it. The memorandum starts with a statement of facts. This case involves a traffic camera citation issued against the appellant. The appellant means Amanda. She's the one appealing. Some of this is legalese gobbledygook, but I'll try to explain it. Most of it's pretty plain and obvious what it means. Issued against the appellant in this case, alleging that the appellant was driving at, quote, a speed greater than is reasonable and prudent under the circumstances. That from Arizona Statute 28-701A. Originally, the appellant was issued 2 citations for 2 alleged incidents occurring hours apart on the same day. At trial, the court dismissed one of those citations, it gives the number, but upheld the other. It gives the number of the other one. At trial, the appellant, representing herself, cross-examined the sole witness in the state's case. The appellant herein disputes the validity of the citation on both evidentiary and constitutional grounds. Argument. So, here we go. Again, I'm not going to give you background because it actually gives it in the argument. The Fifth Amendment to the U.S. Constitution, made applicable to the states by the 14th Amendment, dictates that no person may be deprived of life, liberty, or property without due process of law. In this case, the appellant, meaning Amanda, was deprived of property without being afforded sufficient due process. While traffic court proceedings and rules of evidence are very informal, and while in a civil traffic case the state's burden of proof is merely a preponderance of the evidence, not beyond a reasonable doubt, due process still requires that the state has the burden of presenting reliable evidence introduced by a knowledgeable witness in a manner that allows the accused to assess and challenge the trustworthiness and accuracy of that evidence. That was not the case here. Point 1. Failure to provide due process. While the right to cross-examine witnesses expressed in the Sixth Amendment applies only to criminal proceedings, not civil proceedings such as this one, the United States Supreme Court has nonetheless stated that, quote, in almost every setting where important decisions turn on questions of fact, due process requires an opportunity to confront and cross-examine adverse witnesses, end quote. It's from the case Goldberg versus Kelly, 397 U.S. 254, if you care. And Supreme Court has ruled that the requirement to be afforded a due process hearing, quote, embraces not only the right to present evidence, but also a reasonable opportunity to know the claims of the opposing party and to meet them, end quote. Morgan versus U.S., 304 U.S. 1. Such principles are obviously not fulfilled in a case where the state's witnesses are unable to personally authenticate or fully explain their own exhibits and unable to answer even basic cross-examination questions about their own evidence. In this case, the state's sole witness, I redacted her name, I don't want to embarrass her. She's just doing a stupid, immoral job. In this case, the state's sole witness did not even attempt to legitimately lay any foundation for the exhibits she presented, but simply assumed and asserted that they were accurate and were what they purported to be, even while acknowledging that she had no first-hand experience or knowledge about the supposed violations, and that her testimony was based entirely upon printouts and information provided to her by unidentified, unnamed individuals who were not in court and not available for cross-examination. Indeed, it is barely an exaggeration to say that any stranger wandering in off the street could have read the same prepared statement without any real proof or knowledge regarding its accuracy or validity, and without the ability to adequately respond to even basic cross-examination. No court, however informal the proceedings and rules of evidence may be, should treat such testimony as admissible. Numbers printed on paper in and of themselves, created by unspecified individuals by way of an unspecified procedure in a setting where there is no opportunity to determine or dispute the origin or accuracy of the information, cannot be the basis of actual due process as required by the Fifth Amendment to the United States Constitution. Now pay close attention, because this is, to those of you who've dealt with traffic cameras, you may already know this. I'll say this much. There isn't a prosecutor. There isn't a cop. There isn't anyone for the government. There's literally an employee of the police department who is hired by the private company that runs the cameras. That's the entire prosecution. Is somebody who doesn't know the law, isn't a prosecutor, isn't a lawyer, isn't even a cop, has no knowledge, but was trained to read off a piece of paper by Redflex, a private company that gets lots of money by helping to rob people. The witness identified herself as an employee of the Paradise Valley Police Department, but admitted to being trained by Redflex, a private company which operates traffic cameras. The witness claimed to have, quote, a general understanding of how these systems operate. Citation. Every time I say citation, it's going to be a number that refers to the exact point in the recording of the trial where she said that. I'm not going to read out the minutes and seconds every time because it doesn't mean anything. But these are quotes straight from the audio recording. So the witness said she had, quote, a general understanding of how these systems operate, end quote, but then proved to be ignorant of many important specifics. Then I say, all numbers and brackets in this memorandum refer to the time on the audio recording from the original trial. Based on her own testimony, the witness, and this was the only witness, she was the witness and the prosecutor, like that, there wasn't anybody else there for the state except her, which is kind of weird. Based on her own testimony, the witness had no first-hand testimony to give and was not qualified to testify as an expert witness. By the way, in almost every court, if you're not an expert and have no first-hand testimony to give, they say, well, go away. Like, you have nothing to do with this proceeding. There's literally nobody there with either of those qualifications. Essentially, she was just a person trained to read a pre-prepared statement, introducing exhibits in the form of printouts, which she did not create, coming from machines she does not use or maintain, and indeed barely understands, run and calibrated by people she doesn't know, using methods she doesn't know. Indeed, none of the evidence presented was even reliable enough to count as hearsay, because no actual human beings involved in programming the machines, testing the machines, calibrating the machines, collecting the data, printing out the data, and forwarding it to the witness were present or identified by the state's only witness. The witness herself made all of this clear. When asked if she had any personal knowledge about the case, other than the data that the Redflex cameras produced, the witness replied, quote, I do not. Citation. The witness went on to admit, other than having driven through the intersection and knowing where the cameras are, she had no added knowledge about the intersection or the traffic patterns there. Citation. Amazingly, when asked how the radar devices are actually calibrated to detect vehicle speeds, the witness responded, quote, that's something that you would probably need somebody from, you'd need to call a Redflex witness as far as how they're calibrating their information, end quote. Adding, quote, I have what I have in the maintenance records, end quote, citation. The witness later admitted to being ignorant of the actual calibration process, again adding, quote, that's something that you would have to have a technician from Redflex called as a witness to court, I think, to give you more information on their procedures for that, end quote. When later asked if the witness knew anything about whoever did those calibrations and whether they would be available to cross-examine, the witness admitted, quote, they are not available here in the court today. That's something that you would have to file to have them called as a witness. I do not personally know the Redflex technicians, no, end quote. For the state's only witness to admit such ignorance about even basic information regarding the exhibits upon which the entire case was based, and to then imply that it was the defendant's responsibility to contact or subpoena a witness who might actually be able to give competent testimony regarding the authenticity or accuracy of the state's own exhibits is an obvious affront to the concept of due process and the idea of the state having the burden of proof. Now, I know a lot of you probably aren't into weird legalese garbage because it's all gobbledygook and completely illegitimate anyway, but this is the equivalent of somebody saying, you're accused of, like, Grand Theft Auto. It's like, well, what's your evidence? Oh, I don't know. You'd have to call somebody else to find out what evidence we actually have. Like, you're the prosecution. It's your responsibility to have the evidence and be able to say what it is, where it came from, and defend it. And this witness is like, oh, I don't know that stuff. You'd have to call somebody from Redflex. It's like, okay. Anyway, back to the memorandum. Further demonstrating just how flimsy and incomplete her own knowledge was, the witness testified that, quote, at least once a month, someone goes to each site and manually tests and maintains the system, adding that, quote, this can include anything from cleaning the glass, taking test shots, and or adjusting the zoom, end quote. That sounds real. So if they wipe off the glass, that's good enough. We can just assume they're accurate because once a month somebody might do something like wipe the glass or adjust the zoom. That description comes nowhere near establishing that anything is regularly done to actually confirm the accuracy of the machines. At one point, the witness did assert that, quote, the system is tested against a LiDAR gun, end quote, but gave no further details or elaboration on how or when that is done or by whom. In this case, both the prosecution and the witness were, for all intents and purposes, several pieces of paper generated through some unclear and unreviewable process by unidentified individuals who were not available to testify or to be cross-examined. The state's sole witness was not a witness at all, but someone trained by Redflex to read from a prepared statement which she did not write, did not fully understand, and could not fully explain or defend. When the appellant tried to question the reliability and trustworthiness of claims made by Redflex, a private company, not a law enforcement agency, and mentioned an obvious possible conflict of interests, the witness became even more unsure. So again, Redflex is the company that runs the cameras. They make money every time a citation is issued. They're the ones who trained her. So it's not like, well, you have a dispute between two parties and government in the middle. The prosecution is a private company that isn't there to be cross-examined, that just sends in pieces of paper. When asked whether Redflex financially profits from the issuance of citations, such as the ones in this case, the witness responded, quote, I don't know how the financial stuff is done because that's something done through my superiors, end quote, and admitted that she had no specific information about that. When asked again, she responded, quote, I do not know if they, Redflex, have a direct profit from the citations, end quote. They do, by the way. They directly get a percentage. I mean, I knew that before we even went there, but apparently the people that Redflex trained to read these prepared statements, they don't get taught that. When asked if calibrating the machines inaccurately, even just 1 or 2 miles per hour faster, could result in Redflex seeing a significant revenue increase, the witness responded, I don't know how to answer that, and objected to the relevance of the question. Again, the question was, if they calibrate these wrong, don't they make a bunch of money from that if they calibrate them in that direction? She's like, I don't know how to answer it. And then she complained about the question. In that instance, the judge ruled that Redflex's obvious financial incentive to overstate the speed of vehicles was irrelevant to the reliability of the evidence presented. What a freaking joke to have a judge say, yeah, no, that's not relevant. They obviously would make many millions of dollars by calibrating the thing, even just a little bit off. But you're not allowed to ask about that. That's irrelevant. Just glaringly obvious conflict of interest. However, I think the judge was even embarrassed because the second time it came up, she didn't overrule. When then asked whether the speed camera calibration procedures are done on camera or in the presence of police or court officials, they're not. The witness only responded by saying, quote, the calibration is done by certified technicians with Redflex. A clearly non-responsive answer. So in other words, no, they do their own calibration, not in front of any cops, not in front of the court, not on record. Just trust it. Don't worry. The people who work for the company that would make millions of dollars if they lie about the out, don't worry, they calibrate it. You don't need to know where or when or how. You don't need them to do it in front of anybody or have any visual record of them doing it. Nah, you don't need that. The appellant, that's Amanda, then asked, quote, what checks are in place to ensure either to me or to law enforcement or to this court that Redflex could not just hire unscrupulous people to intentionally calibrate speed detection devices incorrectly or to exaggerate the speed of vehicles and thereby bring in more revenue? Pretty reasonable question. The witness objected to the relevance of the question, but this time the judge did not uphold that objection and instructed the witness to answer. After the appellant repeated the question, the witness responded, quote, I can't answer on Redflex's behalf. End quote. How do we know they didn't just totally fake their records? Huh? Remember, she's their only witness. She's the prosecutor, too. So, yeah, this is some awesome due process. And she admitted she only had the records supplied to her by Redflex. So she's sitting there with pieces of paper going, this is all I have. And that's their whole case. With such an obvious conflict of interest, such an obvious financial incentive for Redflex to rig their system to exaggerate vehicle speeds, and such a complete lack of any checks to guard against that possibility, to then have cases prosecuted entirely by state witnesses with no personal knowledge or experience regarding the events or the equipment involved, and with no personal knowledge or ability to establish that the Redflex evidence is at all accurate, trustworthy, or reliable, is an affront to the concept of due process of law. To wit, a private company could hire anyone moderately familiar with Photoshop to put whatever numbers they want onto a few exhibits with images, print them out, and send some other person, perhaps innocent but nonetheless completely oblivious and ignorant to the actual facts and evidence, to take it to court and act as a witness to extort unsuspecting victims, and there would be exactly the same amount of due process, reliability, and accountability that there is in this case. None whatsoever. Nothing to actually establish the origin or the accuracy of the exhibits. Item 2, we're almost done. Failure to meet burden of proof. The state's only witness again admitted her complete lack of personal knowledge of the alleged violations when it came to the factual specifics of the case. When addressing the issue of whether the vehicle's alleged speed was, quote, greater than is reasonable and prudent under the circumstances, the witness admitted that the images for both citations, because there's pictures, little black and white grainy pictures on the citation, admitted that the images for both citations showed conditions to be during daylight, citation, that she saw no conditions of reduced visibility, citation, that at the point where the pictures were taken, the road is straight and wide, citation, that the road appeared to be dry, citation, and that the vehicle was proceeding straight through the intersection rather than making a turn, citation. Regarding the first citation, the one which the judge upheld at the original trial, when asked how far ahead the road would be visible to the driver of a vehicle in that position, The witness admitted, quote, "That is not something that I could answer," end quote. When asked about other vehicles and pedestrians in the images taken, the witness admitted that she could not give the actual distances to other vehicles, and went on to admit that regarding the first citation, no other vehicle appears in any of the images other than one vehicle going in the opposite direction. And that was actually already passed by like 100 yards. The witness also admitted that there were no pedestrians visible in any of the pictures for either of the citations. And I give the time marks all the way through this, where in the recording she said all these things. So it's very specific and documented. Regarding the first citation, the witness was then asked if the vehicle cited appeared to be at any risk of, quote, colliding with any object, person, vehicle, or other conveyance on, entering, or adjacent to the highway. And that is quoting from the statute that the citations were issued under. It's Arizona Statutes 28-701. So it was basically asking, was Amanda allegedly driving in such a way to be in any danger of colliding with anything? The witness answered, quote, "I believe I've already answered that there were no other pedestrians or vehicles in those images," end quote. When asked again if it appeared to the witness that the vehicle was at any risk of colliding with anything else, the witness responded, quote, "In the photograph, no, it does not appear to be," end quote. So the basis of the statute that the citations were issued under is this in danger of colliding with anything. Their only witness said, no, it doesn't look like it. The witness was then asked similar questions and gave similar answers regarding the second citation, which was later dismissed by the judge. When asked again if the witness saw anything the vehicle was at risk of colliding with, the witness admitted, quote, "I do not see any vehicles or people," end quote. While posted speed limits are considered prima facie evidence of what may be a reasonable and prudent rate of travel in a particular location, that is not the end of the inquiry. For those of you who don't know, prima facie is sort of like, well, we assume this is evidence of something unless something else contradicts it. So it doesn't mean that's it. If it's posted, if there's that number on a thing, that's the end of it. And the Arizona, like other states too, the Arizona speeding statute doesn't say you went faster than that number says. It says you went faster than was reasonable and prudent, and later it says the posted limits are prima facie evidence of what we think was reasonable and prudent. That doesn't mean that can't be disputed, which is why the memorandum says that that number is not the end of the inquiry. And in this case, the state's only witness, based upon her own exhibits, essentially described ideal driving conditions as far as visibility, lack of traffic and pedestrians, etc., and openly and specifically agreed that the vehicle did not appear to be in danger of colliding with anything, while having nothing to add about the particular circumstances or conditions which would make the alleged rate of travel greater than is reasonable or prudent. Then in parentheses, there are numerous four-lane roads in the Phoenix area with worse visibility, much higher traffic congestion, and pedestrian activity with posted speeds significantly higher than 40 miles per hour, which is what the speed limit was there. The appellant then brought up the fact that being mailed a citation many weeks after an alleged violation does not afford a defendant a reasonable opportunity to remember the details and conditions at the time of the incident or know how fast she was going. This is a fun thing. I'll mention this even though we didn't put it in the memorandum. She actually asked the witness, do you know how fast you were driving? I forget exactly. It was 3 weeks, 2 days, 5 hours, and 16 minutes ago. And the witness was, of course, I don't know. The point being, it takes a picture and it mails it to you weeks later, and you're supposed to remember the exact conditions and how fast you were going, like you're going to remember that long after the fact, what your speedometer was saying or the conditions around you. So brought up the fact that, there's no way you can reasonably expect somebody to remember something that they had no way to notice until weeks later. If somebody happened to notice the flash and knew what that was and remembered it and made a mental note, that's one thing. But it's we got a thing in the mail. What's this from? You're going to remember weeks later exactly how fast your speedometer said you were going. So we, kind of made a point to make fun of that. The state's witness in this case admitted that, quote, for most people, they probably would not remember the speed that they were traveling at, end quote, many weeks later. And while saying that some people might remember the details of the situation and conditions if they happened to notice that the traffic camera had flashed, the state's witness admitted, quote, I can't answer that for any individual other than myself, end quote. So she basically admitted, no, people aren't nearly, can't be nearly expected to remember that weeks later. This delay in notification of the alleged violation results in a situation where the state has no witnesses with any first-hand experience or knowledge of the event at all, and the defendant, the only one there to have any actual first-hand experience and knowledge of the event, is very unlikely to remember such things by the time a citation is received. This by itself makes it so that such traffic camera citations mailed days or weeks after an incident are inherently incompatible with affording a defendant basic due process. It is impossible to make any objective and fair determination about whether a vehicle's speed was reasonable and prudent given particular conditions and circumstances when only one human being, the defendant, was present to actually witness the conditions and circumstances, and even that one person cannot reasonably be expected to have reliable memory of such things many weeks after they occurred. Conclusion. For the foregoing reasons, the appellant hereby asks this court to set aside the traffic court's decision in this case, to dismiss the citation in question, and more importantly, to issue an order prohibiting the prosecution of any similar cases which rely entirely upon witnesses who are and should be legally unqualified to testify or to present any evidence or exhibits by reason of, number one, having no personal knowledge of the cases, and two, having no legitimate status as expert witnesses, and three, being nothing more than presenters trained by and working for private companies which have an obvious vested financial interest in issuing and enforcing citations regardless of their accuracy or legality. So, I don't know what will become of that. We actually had to pay the ticket in order to appeal the thing. It's like, well, you have to give us that much money anyway. So at this point, they already, robbed her. And all that can happen is we might get it back if the superior court has any honesty whatsoever, which, I don't know, they may or they may not. It's lower court stuff, so it can totally go any other direction. And, of course, we have to pay them for the privilege of pointing out how badly they broke the law. So the filing fee for the appeal was like $160. So actually, people already chipped in $50. I'm going to throw in the description if you want to chip in a little bit by PayPal to help us cover that. That would be cool too. But the reason I do this, whenever there's an individual thing that comes up, like I said, in the grand scheme of things, who cares? It's a dumb little traffic citation. Doesn't even really matter. But imagine how different the world would be if every stinking time the bureaucratic parasites did this, somebody would fight it. They would go to trial, and they would appeal it every level they could. I happen to know how to do it without having to hire a lawyer. Like a lot of people are just like, well, it's not, for a $274 ticket, I'm not going to hire a lawyer who's going to cost 5 times that much just to talk to him for an hour or something. So most people just give up because they don't know how to do it and can't afford a lawyer, and it just seems like a pointless waste of money and time to even try. Even if they were to win, the lawyer would usually cost more than the ticket. And there may be some cases where the lawyers do a deal where we only get paid if we win for you and stuff like that. But most people are just like, oh, just pay it. Pay the extortionists and be done with it. And I totally understand that. I'm not even faulting people for that. But think how quickly rackets like this would just crash and burn if every single victim of them said, no, I'm going to drag you through it. I'm going to make you take the time and effort and bring in the witness who doesn't know what she's talking about and waste the court's time listening to this ridiculous case based on pieces of paper and nobody knows where they came from and how they were made. And then go to the next court up. It's like, if you're going to try to rob me, I'm going to make it as hard as possible. If everybody did that, the entire system would literally collapse. The traffic camera system would collapse. Most traffic citations would collapse. Most of their stupid little rackets, where they, ticket people for having tinted windows and stuff. If people would challenge this stuff, and again, I understand why a lot of people just go, oh, I don't want the bother, it's not worth it. I understand that. I'm just saying, if everybody did say, well, I'm going to make it as in, I'm not going to help you. I'm not going to say, okay, I admit it, here's some money. I'm going to make you prove it. I'm going to drag you through it, even if there isn't even an argument. It's just, nope, I'm going to go to trial and make you have to prove it before I'm going to give you any money. If people did that, the burden on these extortion racket, just conveyor belt robbery machines like traffic courts, they would just implode. So anyway, we'll see how it turns out, but I hope you found it mildly entertaining, and just one more example of how governments just lie and cheat all over the place. They barely even try. They barely even pretend to give anything like due process, where the entire prosecution is some random person who was trained to read off a piece of paper. Like, really? I'm allowed to confront the witnesses and there aren't any? There's this clueless person with some pieces of paper that came from who knows else, and however they did it, whatever. Just take their word for it and give them lots of money to this private company. Not even a cop giving you a ticket, it's just a private company that mails you a thing. Incidentally, in Arizona, I don't know how many other states it's true of, if you get a traffic camera thing in the mail, you don't have to do a damn thing. It's only if they actually serve it on you. And by a weird coincidence, they happen to luck out and actually serve it on us, like right before the time limit ran out. But if they just mail them out, and most people don't know that if in Arizona, if they mail it to you, you can just freaking ignore it. Until they actually legally serve it on you, it doesn't mean anything, and there's no obligation to do anything. In this case, they happen to luck out. But then we, asked for a trial, and Amanda went in and did that, and we got to recording, and now we're doing the appeal, and we're making them work for it, and wasting their time as much as possible if they're going to be a bunch of parasites. So, yeehaw! So hopefully that was mildly entertaining or amusing or annoying or something. But that's all for now.